where we discuss everything having to do with criminal law and family law in Massachusetts. At Afford Law, we charge our fees on a sliding scale. Our fees are based on our client's income. So the less you make, the less we charge. Today, we're going to be addressing the issue of child support modification. What is child support modification? When can you get a child support order modified? And what does a judge look to when making such a decision? These are the things that we're going to be examining today. So let's just back up and just say that child support is one of the most critical issues in a divorce or a paternity action in the Probate and Family Court in Massachusetts. It affects so many things. It's so important to you, your ex, and most importantly, your child or your children. Excuse me. When you get divorced or when you separate from your ex, if you have a child together in a paternity action, a child support order will go into effect. So the court will order child support from one party to the other to financially support the children. Oftentimes, during the course of the child's life, when they're a minor, the parents will have changes in their income, in their resources, and so forth. And so very often a parent will want to modify or change the child support order. Because of that, the court has a process for that. In order for a child support order to be modified, two things must happen at the same time. First, you must be able to show that there has been a significant and substantial change in circumstances of the parents. Typically, because it's child support, we're talking about the income or resources of the parents. And the second step is there must be the proposed change must be in the best interest of the child, so that even if you get over that first hurdle of the substantial change in circumstances, you must also convince a judge that the changes that you're asking for are going to benefit the child. What is a material and substantial change in circumstances? Well, it's not a minor change, as that title would indicate. A minor change won't be enough to change a child support order in Massachusetts. You have to show that there's some significant change in your income, in your resources, or that of the other person, the other parent, in order to get over the first hurdle to even have the judge look into the case to see whether a modification is in order. The reason for that is that courts want to keep all the orders in place. They're looking for consistency. They don't want parents or litigants to come back in front of the court time and time again for minor changes and thereby possibly upsetting the child's life. So it has to be a significant change in circumstances. What are those change in circumstances? Typically, they are if one spouse either changes their income for the good or for the worse. So, for instance, if you lose your job, if you're the paying parent, so you are the non-custodial parent, you're paying child support to the other parent, you lose your job for no reason caused by you. If that's the case, you don't have income, you should submit an order to modify the child support as quickly as possible. Your child support won't be lowered simply because you have a change in your income. You have to be able to show the court that there's been a change in income. And it's important to file that right away, because no child support modification can go further in the past than when the motion is filed. So let's just take an example. So say you're working on July 1st, you get laid off, so you're no longer employed. You wait until July 15th, for instance, to file an order, and your child support order modification hearing doesn't take place until June 30th. Just making up these dates. Even though your income was reduced on July 1, the best the court can do is backdate the child support modification to July 15th when the modification motion was filed. Does that make sense? Okay. So it's important to act on it right away. Don't sit back and think, oh, it's going to get lowered and I'll take care of it later. It's extremely important because you're still on the hook for the full child support for whatever that order is until the order is modified. So again, there are a number of reasons why a child support modification might be in order. As I say, a change in income or resources for one of the parents, child or health insurance for the child is no longer available, say through the parent's employer, or child support. The child's health insurance is now available to one of the parents through their employer at no or little cost. So that could be a change that would give rise to a child support modification. Also, if there's been a significant change in the child's needs, so let's just say the child has some serious medical, God forbid, serious medical issues that crop up where they require more help, more assistance, and more money. That could be also a reason to change the child support order. Sometimes we get asked at a forward law, can I change or can the child support order be changed without going to court? The short answer is no. Even if you have an agreement, an informal agreement between you and the other parent that child support will either be increased or decreased, that order, that agreement is not enforceable. So let's take an example. So let's say that you are the paying spouse. So you are the non-custodial spouse who is paying child support. Something happens, you come to an agreement with your ex that say, and he or she says, that's okay. You can give me half of what you usually do. I'll take half now, but keep paying the one half. That's not good enough, and a lot of times people get into some serious trouble with that because what happens is a court hasn't issued a modification on that order, so the original order is still in place. So what happens frequently is that so you go on paying one half of the original order, thinking that everything is fine. And then somewhere down the road, your ex turns around and says, hey, you haven't been paying the full amount. I want that money now. He or she takes you to court, and the judge looks at the last court order, and it says you owe X amount of dollars per month. Even though you have an agreement and he or she has been accepting the lesser amount for a period of time, that's not good enough for the judge. You're still on the hook for the entire thing. So if months go by and then you get taken into court and the other person says, hey, look, we had this agreement, but I still want all the money that's owed me. You are now in arrears for all the money that you haven't paid under the original court order for that length of time. So obviously that's a very bad situation. You don't want to be put in that situation. So the thing to do is we need to file a motion to modify child support, and we need to have a hearing to modify in front of a judge and have a judge make a determination as to what the proper amount is under the new circumstances. Excuse me. So let me just take a little sip here. Another question we often get is, if my ex or I get remarried, does that affect child support? The simple answer is no. What the reason behind that is that each parent is responsible for the financial support of the child or the children. That burden or that responsibility does not pass to any additional spouses. So if you get remarried, your new spouse is not responsible for paying child support to your child with that other person. That being said, the judge can take into consideration any change in the household circumstances, the resources of each of the parents. So, for instance, if you are receiving child support at a certain amount, your ex gets remarried and marries somebody who's making a lot of money. So now their household income has increased significantly, obviously. That alone is not enough to change child support. However, because that household now has additional resources, that in a sense frees up your ex's income to possibly pay additional support for the child that you have in common. So remarriage on its own is not enough, but it can be a basis, or at least it can be part of a basis for you to ask for a modification. Another question is there any risk to filing a motion for modification for child support? And on this, I will tell you that yes, absolutely there is a risk, and you should consider the risk. The risk being, When you go to modify a child support order, you have to supply your financial information, and your ex has to supply that financial information, their financial information as well. The court will take a look at that. If you're going to if you're asking the court to reduce your child support, the court will take a look, the judge will take a look at the financials and will make a decision based on that. And you may get a reduction in your child support if that warrants. However, the judge, in looking at the financials, will also take, as I say, take both people's financial situation into account, and that may force the judge to increase your child support. So you're going in asking for less, that you may come out owing more. So you want to be very careful about that. Another thing is, oftentimes we see when one person moves to modify a support order, or yes, a child support order, the other party, once they get served with this, with the papers that they have to go back to court on this issue, may file a counterclaim. So they may ask for something else. They may ask for an increase in the child support. It may prompt them to ask for a change to something else in the order, such as child custody. So that's a risk that you need to assess, and you need to have the information to make that decision. So at the very least, we would want to run your numbers and the what you expect your ex's numbers to be as far as their financial situation, so that we can see if indeed there is a significant change in your incomes, and therefore could warrant a decrease on your side. But keep in mind that these other issues could be in play as well, and it may in the long run be better for you not to modify the child support and to keep everything else as is. But that's on an individual basis. Every case is different. Every person is different. Every parent and child situation is different. So there's no hard and fast rule about that. That's why you need to seek professional help. You need to get an experienced child support modification attorney on your side, so that you'd be able to best prepare, and in that situation, simply whether or not you can make that decision, whether it's worthwhile to go forward or not. So thank you for tuning in here. I hope that's been helpful. Again, at Afford Law, we offer reduced rates depending on our client's income. We don't want you to have to face a criminal case or a family law case, such as child support, on your own. There's too much involved. There's too much that can go wrong, and there's too much at stake. So please feel free to give us a call or visit us at affordlaw.org. Take a look around. We have a lot of information on there. Email us any questions that you might have. We'll be here on Saturday afternoons at noon to answer any questions. We'll be opening up questions to emails and direct messages and so forth. So again, hope that's been helpful. Give us a call if you think we can be of any assistance whatsoever, and we'll be happy to see if you qualify for our reduced rates. At Afford Law, we're making justice affordable. Thanks again.